Hello and welcome to the UPSC Quick Revision series. Today we'll discuss one of the most vital articles of the Indian Constitution, Article 32, the right to constitutional remedies. Dr. B.R. Ambedkar famously called it the heart and soul of the Constitution because this article makes our fundamental rights real and enforceable. It grants every citizen the right to approach the Supreme Court directly if their fundamental rights are violated. Here's what we'll cover: the key provisions of this article, the 5 types of writs, the difference between Articles 32 and 226, and the conditions under which this right can be suspended. Key provisions and significance. Under Article 32, any person whose fundamental rights have been violated has the right to move the Supreme Court directly. This article empowers the Supreme Court to issue directions, orders, or writs to enforce these rights. While Parliament can empower other courts to issue writs, it has not done so yet. Most importantly, this makes the Supreme Court the defender and guarantor of fundamental rights. Since the right to move the court is itself a fundamental right, the Supreme Court cannot refuse to hear such cases. Writs, Habeas Corpus and Mandamus. Now, let's understand the 5 types of writs. First is Habeas Corpus, which literally means to have the body off. This writ is issued to challenge the legality of a person's detention and is a powerful safeguard of personal liberty. The second is Mandamus, which means we command. This is a command from the court to a public official, asking them to perform their official duties which they have failed or refused to perform. It cannot be issued against a private individual, the president, or state governors. The next 2 writs, Prohibition and Certiorari, are issued against judicial or quasi-judicial authorities. The third writ is Prohibition, meaning to forbid. It's issued by a higher court to a lower court or tribunal to prevent it from exceeding its jurisdiction. This is a preventive writ, issued while proceedings are still pending. The fourth writ is Certiorari, meaning to be certified. It is also issued by a higher court to a lower court, but it serves to quash an order already passed or transfer a pending case to itself. This is a curative writ, issued after a decision has been made. Writs, Quo Warranto and Article 32 verses 226. The fifth and final writ is Quo Warranto, meaning by what authority. This writ is issued to inquire into the legality of a person's claim to a public office. Now, let's compare Articles 32 and 226. While the Supreme Court can issue writs under Article 32 only for fundamental rights, the High Courts under Article 226 can issue writs for both fundamental rights and other legal rights. Therefore, the writ jurisdiction of the High Courts is wider than that of the Supreme Court. The Supreme Court has held that Article 32 is a part of the basic structure of the Constitution and cannot be taken away, even by an amendment. As we noted, it can only be invoked for the violation of fundamental rights, not other legal rights. This right, however, can be suspended. Under Article 359, the President can suspend the right to move any court for the enforcement of specific fundamental rights during a national emergency. However, the enforcement of rights under Articles 20 and 21 can never be suspended. Let's test our understanding with some practice questions.